Welcome to 80/20 Estate Planning, the show that explains smart ways to get the most from your estate and planning team, with your host, Al Gibbons. In this 13-week series, Mr. Gibbons and his guests will be discussing a multitude of critical and helpful topics, including his own 80/20 process. Feel free to call in with your questions, 621-WALE or 1-877-621-WALE. Now, 80/20 Estate Planning with Al Gibbons.
Welcome to all of our listeners. This is Al Gibbons, host of the 80/20 Estate Planning Series, Part 3 of a 13-part series. Today we'll be talking about 80/20 estate planning, how to get 80% of estate planning done in 20% of the time normally required, how to get through that process from A to Z in 60 days. I have two outstanding guests with me today, both attorneys specializing in estate planning. First, let me introduce Suzanne Hecht, co-founder and shareholder in Haney and Hecht, a law firm in Malvern, Pennsylvania, a suburb of Philadelphia. Suzanne counsels and advises individual clients, families, and closely held businesses with respect to all aspects of estate and business planning and property transfer and disposition. In addition, Suzanne's a specialist in estate and trust administration. Furthermore, a unique quality for Suzanne, she has also co-founded 3H Software for the purpose of developing software and utilizing the Internet for estate planning applications. Welcome, Suzanne. Happy to have you with us.
Thank you. Very pleased to be here.
Great. Also, let me introduce Kevin Danyi, JD-CLU. Kevin is a graduate of the New England School of Law where he got his law degree and currently is at Villanova University, an LLM candidate in the graduate tax program specializing in federal taxation, estate planning, and family wealth transactions. Kevin has offices in Bethlehem, Pennsylvania, and in Wayne, Pennsylvania, another suburb of Philadelphia. And Kevin, it's a great pleasure to have you with us today.
Thank you very much, Al.
Great. We are going to do a lot this afternoon. We're going to be talking about wills, about selecting guardians, executors, and trustees, and other estate planning tools such as a durable power of attorney. So we have a lot to cover. We want to get right into it. We'll take your questions after the first segment. In about 16, 17 minutes after the hour, we'll begin the questions. So feel free to call us and get the answers to your questions. Suzanne, let's start with you. Let's talk about wills. What is a will, and what's the purpose of a will?
Well, Al, a will is a document that you draft during your lifetime that directs what happens to your assets after you die. In addition to directing who is to get your property after your death, it gives you the opportunity to determine who is going to manage the administration of your estate, who's going to be the guardians of your children if you have minor children, and who is going to be in charge of any trust that you've set up.
Okay. Other elements of a will. Kevin?
Well, the will can be as simple or as complex as you'd like it to be. You can go from, I've seen the one-page specials or the 50-pagers, and you can put trusts inside a will if you want to, and those are called testamentary trusts, as opposed to all the other different kinds of trusts that we're going to talk about today.
Okay, great. So would you say that a will then directs where you want your property to go, the things that you've accumulated during your life, who's to receive those, and how it's to be received and when it's to be received? Is that what a will does?
It directs, if I may jump in ahead, it directs where certain assets go. And this is one of the problems that I see all the time. People don't realize that the will only controls assets that you own in your own name that are called probate assets. In other words, if I have a house and it's in joint name with my wife, the will has no control whatsoever over that house. When I die, the moment of my death, the house, title to the house vests in my wife, meaning it's hers.
So that is done by titling then, not by will?
That is correct.
Okay.
The second part of it is there are a lot of assets out there, IRAs, 401ks, 403bs, that do not pass through the will. And I had a client come in, I don't know, about 2 months ago, and he had just a really great will. This was a Cadillac, a Mercedes of wills, with credit shelter trusts and all kinds of neat things. And I went over his assets, and I said, well, this is really nice, but it's unfortunate because it isn't going to work. And he looked at me in horror and said, what do you mean it's not going to work? And I said, well, you have an $800,000 IRA, and the beneficiary of your IRA is your wife. The will has no control over that IRA.
Well, Suzanne, then, let me ask, if it's not unusual in today's world, where, especially when the stock market was really going up, to have a large retirement account, such as an IRA or some other kind of retirement account, as Kevin mentioned, not unusual to have a home that's appreciated greatly over the course of the marriage, and to have some life insurance. And is life insurance governed by the will then, or what about these assets?
No, the life insurance, like the retirement assets that Kevin referred to, the disposition of the proceeds of life insurance is governed by what you say in the beneficiary designation. But I think the key to all this is that you have to be aware of it. And simply the fact that you have those assets doesn't make you say, then there's no sense of me doing a will. You still need to do the will, but what you have to make sure is that you've coordinated the beneficiary designation on all of your retirement accounts as well as your life insurance in with the disposition that you've done in your will.
Okay.
We do the same thing, Susan. We do a holistic approach of what do you have, what do you owe, and who do you want it to go to?
And Suzanne, I know you do that because it's real important, I guess, for the attorney and other financial advisors to have a list of all the assets, all the property that's owned by your clients, so that you can make sure that it's all coordinated.
And it's so important now that we've stopped asking clients to complete those beneficiary designations and have requested that they allow us to do it. So when we do an estate plan, we'll sit down with clients, we'll sign the documents, and then I'll say, now give me the beneficiary designation forms that you've collected, and I'll complete them and have the client sign them and submit
Suzanne,
them.
I think
we do the same thing.
I think that's marvelous because so often clients will say they will get to it, or they will attempt to do it, or maybe they forget because some forms don't come through. And I know that both of you have checklists on getting those forms. So not only are you doing the planning, but what you're telling me is that in your specialty, you're also helping with the implementation and making sure that the I's are dotted and the T's are crossed.
That's correct.
I love that. I think that is terrific. Well, let me ask a question then a little bit differently. I wanted to know, sort of thinking about the program, who should prepare the will, or maybe first of all, who should have a will? When we talk about estate planning, we often think of people with high net worth, but in general, who should have a will? Should most people have a will?
Absolutely.
Okay, then if most people should have a will, who should draft it? I hear things that there are programs on the internet, or you can go to the library and draft one. What do you think?
I think that in some cases that it is possible for you to have a well-drafted will that you did yourself from some sort of will compilation software or from the internet. The problem is it's hard for individuals to be aware of when the issues exist that would make it more appropriate for a professional to draft the will.
So you're saying it's also hard to know the question.
Exactly.
Yeah.
And I think that everybody would agree that when an individual has a net worth that makes tax planning relevant, then absolutely they should not be doing the will themselves. But beyond that, people sort of forget and say, well, all that I need is a simple will. But if you have minor children, you don't need a simple will. If you have elderly parents that you're taking care of, you need more than a simple will. There's a lot more to it, I think, than people realize. And if they were able to ask the questions, I'm sure that they could answer them. It's coming up with the questions that creates the issue.
Okay, good. Kevin?
I've seen two different things. Well, first of all, homemade wills are kind of like home dentistry. It just doesn't work. And it causes more problems, in my experience, in 16 years, it causes more problems to do it yourself than to have an attorney who does this on a regular basis. And that's the second part of it. You don't want to go to your cousin who is a great criminal attorney. If you come to me and you're accused of murder, forget it. You're going to go to the electric chair because I don't know the first thing about defending a murder case. But people will go with substantial wealth, and substantial is whatever you consider it to be. They will go with that amount of money or problems or issues, and they'll go to an attorney who does not necessarily do more than a dozen of these, if that, in a year.
Right. Well, I think those are good points. I have to tell you that I have heard of people and talked with people who have tried to prepare wills on their own. And I must say, I tried to put myself in their shoes, and I would not sleep at night. I would not have peace of mind that I had done it properly. And I agree with both of you that in most cases, is it possible to draft a will on your own? I guess it is. I think it's highly unlikely that it will be done properly. And I think both of you make very good points in that regard. The alternative to having a will, I guess, is not having a will. And what's the term for that, Suzanne?
That's intestacy, and that basically is where your state provides the terms of your will as far as who gets your property. It doesn't have anything to do with how they get it or when they get it, but it will determine who gets your property. And I'll tell you, Al, in most cases, I think people would be shocked at what their state law provides.
Yeah, absolutely. Both of you are Pennsylvania lawyers. We're on a national program, but can you give us some clue what intestacy might be like in the state of Pennsylvania?
Well, in Pennsylvania, if you're married, but at the time that you die, you have either children or parents that are alive, your spouse basically is getting half of what you have. And I think that in most cases, that is not what people expected.
I wouldn't think so.
And more so, the spouse may think that they're entitled to everything, and all of a sudden you have these other people coming in saying, where's my half? Well, not their half, but their portion of that half. And there's an entire table of the way it goes, I say. I always point to this big wall in my office filled with in Pennsylvania, the books are green, Purdon's statutes. And I point to those and I say, that's what, in a sense, you're paying me to do, is interpret that for you. And the one thing that you want to do above all others is avoid going to court. Or, well, you won't be going to court because you, as the person who is drafting the will be dead. But your kids, your wife, your husband, whoever else is involved, they could, unbelievable, lengthy court battles and expenses.
And have both of you represented clients in that kind of process?
Yes.
Suzanne, have you...
In an intestacy process?
Yeah, or, where there's been disputes like this?
Sure.
Yeah.
Sure. I mean, and the disputes can happen now whether there's a will or not. But what happens is there's when you don't have a will and it's left up to what the state law is, there is a ton of room for interpretation. When you have a well-drafted will that's covering all the points it ought to cover, there's far less questions and far less ambiguity.
Well, I do want to talk about, continue this discussion. We're coming up for a break, and let's make sure that we come right back here and pick up where we left off and welcome some calls. Thank you.
Okay.
80/20 Estate Planning will return after these short messages. We are a large corporate law firm and require our workflow processes to run effectively and reliably. After researching the market for a networking faxing solution that was easy to use and integrate into our group-wise email system, we chose ACPAC's FaxServe. It provides the tightest integration with GroupWise, and it allows our employees to send and receive laser-quality faxes right from their workstation. We set up the system quickly and easily, and in no time at all we were using the system. One of the greatest advantages is that there is no learning curve for the users. Because of the tight GroupWise integration, we did not need to install software on every desktop. This saved us days of installation and training time. Now FaxServe routes incoming faxes to each user's email inbox, providing full confidentiality of faxes to the designated person or persons. Our employees are now able to send faxes via their GroupWise email as easily as sending any email. Faxes are saved to the network in a digital format, so we don't have to store paper documents anymore. Faxes can be forwarded over the network, so we are not wasting paper or time refaxing the same document over and over. FaxServe is a perfect solution for your business too. For more information on ACPAC's FaxServe, visit www.faxserve.com or call 1-800-808-7000 or Viable Solutions Incorporated at 1-800-679-7626.
Money. It's just not what it used to be. Among other things, it's younger. But new money and old money have at least one thing in common. Phoenix, a company that's been helping people manage wealth for nearly 150 years. Phoenix understands that making money and knowing what to do with it are two very different skills. Call 1-888-456-3451 or visit us at phoenixwm.com. We could bring harmony to your life, if not to your music.
Is your business in need of capital funding, acquisitions, expansions, or other capital-intensive projects? Access Capital can help. Access Capital is not interested in profiting from another's disadvantage. They are there to help. The cash flow division provides cash for daily operations primarily through the purchase of accounts receivable, purchase order funding, or equipment leasing. In its major funding division, Access Capital has the ability to negotiate directly with the funding source in a variety of disciplines in full confidence. There are no prerequisite fees for major funding applications. The proof is in the pudding. Contact them today at 1-888-502-3187. That's 1-888-502-3187, or visit their website at www.access-cap.com. That's www.access-cap.com.
Talk to our expert host. In the Providence area, call 621-WALE. Outside the Providence area, call toll-free 1-877-621-WALE.
And now back to 80/20 Estate Planning. Here's your host, estate planning expert, Al Gibbons.
Welcome back. I'm with Suzanne Hecht and Kevin Danyi. And Suzanne, we were talking just before the break about intestacy that is dying without a will. Is that always bad?
Well, I think the answer is that it usually is. And one of the things that people focus on is where the property is going to go. And that is, in some cases, the same under intestacy that it would be under the will. The problem is how it gets there and the process of administration of getting it there. I had elderly clients, a man and a woman. They had no children. Their parents were deceased. So under the intestacy law, if one were to die, everything was going to go to the other. The problem in this case were a couple of things. First, a typical provision in a will, Al, waives the requirement that the fiduciary that you've named post a bond. Because there was no will in this case, the bond requirement was not waived. So we had a spouse that was required to actually post a bond, which is, not tremendously expensive, but certainly a nuisance, before she could be appointed as the administratrix of her husband's estate. Moreover, and where this got really troublesome, is by the time the administration of the estate was complete, the spouse her competency was really waning. So we had a situation where she was going to be receiving all of these assets outright and really had no competence to manage them. So the result was that we wound up in court having a guardian appointed. That process of doing that was time-consuming, it was embarrassing, and it was expensive for her. That all could have been avoided had there been a will with a trust set up for her benefit.
And is that how you would have written the will then and drafted the will? You would have provided for those kind of contingencies?
That is correct.
Yeah, okay. So for the most part, intestacy is bad. That's a bad word. And I guess as we look at stumbling blocks then to doing wills, well, let me see, what could be a stumbling block? I guess if people thought that it was going to go the way they wanted to go no matter what, I guess just out of sheer inertia, then they might not do something because they don't have to. It's all going to go to my spouse, but as you said in Pennsylvania, half would go to the family or could go to elderly parents and so forth. Secondly, I guess in some cases, the cost of doing a will might bother some people. On the other hand, it would seem the cost of not doing a will, Suzanne, especially in the case you just mentioned, was considerably higher and really much more painful and costly emotionally. So we have those kinds of stumbling blocks. But you started to talk about administratrix and so forth, and the court appointing people. I want to talk about some stumbling blocks to getting wills implemented. And one of the things that I see when I work with estate planning teams is I see the selection of guardians, the selection of executors, the selection of trustees. I see that as stumbling blocks that tend to bog down the whole process. Kevin, does that happen in your experience? Does that bog down the process, and should it?
It's actually happened to me personally because it took us a long time. The executor was easy, but picking the guardian was very difficult.
Okay, well, let's talk about that for a minute. What is a guardian?
Well, you have a guardian. If you have minor children, somebody has to have legal care and custody of that child. And I'm talking Pennsylvania law. Mm-hmm. Early on in my career, I was counsel for the Children, Youth, and Families Division up here in Northampton County. And some child who is without proper parental care or their parents are deceased, they could be adjudicated dependent. You've heard the old term, a ward of the state.
Right.
Well, that means that the government takes care of what happens, and they appoint somebody. They may appoint a bank or an uncle or an aunt, something like that. But the bottom line is either you do it or the government does it for you. And again, it all comes back to that building. Anytime you go into the courthouse, it's going to cost a lot more than if you walk into a law office. If you go in and take care of the things ahead of time, it could cost hundreds of dollars rather than thousands of dollars, or thousands of dollars rather than tens of thousands of dollars. I've had some cases that have gone on for years.
Kevin, if I come to you and say, Kevin, I want you to draft my will, and I have this, Kathy and I, my wife and I have this issue of who should be guardian. I think it should be my brother, and she thinks it should be her sister. I guess that's an unfamiliar one, huh? Just about every time you hear it. Well, Suzanne, what do you do?
Well, you have a lot of options. I think that, one, you counsel a client that you know, who is going to be ultimately appointed the guardian of the person that has the care and custody of your child. The court is going to perform, the orphans court in Pennsylvania and whatever the court of competent jurisdiction in other states are going to perform an evaluation to make sure that who the designated person is in the best interest of the child, which means, as far as I'm concerned, is you don't have to be concerned about somebody, you know, going off the deep end 5 years from now and you've designated them as guardian. And having said that about the court performing the evaluation, it will give enormous deference to who you have named. If you cannot get people to, if you have people that have differing ideas, couples who have differing ideas, and this was the case with my husband and I when we first had children, because in my family we were among the first. So we were in a situation where people didn't have kids yet, and we didn't know how people were going to be with kids. And in our specific case, my husband named his brother and I named my cousin. And we had different guardians for about 5 years. Until, now that people have gotten older and have their own children, we have since agreed on who the guardian of our kids should be. But we just decided that it was not worth holding up the entire process, that it was irresponsible of us to hold up the entire process just because at that point in time we had different ideas. The bottom line is nobody can do it like you do it. And to try to conceive of somebody doing it like you do it is just totally foreign.
That sounds just like us. We had the same kind of problems.
So this is usual.
Yes.
Absolutely.
Okay.
And I do think that guardians, because it's personal as opposed to financial, is the trickiest of the three, basically of the three fiduciaries that you have to name when you do an estate plan.
Well, we started with the hardest one.
Right.
Now, we're going to come up to a break. I want to get back to this. I want to see how we get through this then. And let's go on and talk about executors and trustees, and we'll do that right after the break.
80/20 Estate Planning will return after these short messages. We are a large corporate law firm and require our workflow processes to run effectively and reliably. After researching the market for a networking faxing solution that was easy to use and integrate into our group-wise email system, we chose ACPAC's FaxServe. It provides the tightest integration with GroupWise, and it allows our employees to send and receive laser-quality faxes right from their workstation. We set up the system quickly and easily, and in no time at all we were using the system. One of the greatest advantages is that there is no learning curve for the users. Because of the tight GroupWise integration, we did not need to install software on every desktop. This saved us days of installation and training time. Now FaxServe routes incoming faxes to each user's email inbox, providing full confidentiality of faxes to the designated person or persons. Our employees are now able to send faxes via their GroupWise email as easily as sending any email. Faxes are saved to the network in a digital format, so we don't have to store paper documents anymore. Faxes can be forwarded over the network, so we are not wasting paper or time refaxing the same document over and over. FaxServe is a perfect solution for your business too. For more information on ACPAC's FaxServe, visit www.faxserve.com or call 1-800-808-7000 or Viable Solutions Incorporated at 1-800-679-7626.
Today's money. It's not just who you are, it's what you're made of. It's not just having a name, it's making one. Not just being, but creating. In fact, 8 out of 10 today's millionaires aren't inheriting their money, they're earning it. That's not just evolution, that's revolution. And one company understands how money has changed, and that company is Phoenix. Call 1-888-456-3451 or visit us at phoenixwm.com, because money is not what it used to be.
Are you growing tired of sports talk with more mindless banter than sports? Get the latest, most intriguing sports talk on the airwaves every Tuesday from 6 to 7 p.m. right here on WALE 990. Get in the Game with Dave Rothenberg will give you the inside edge on the latest sports topics. So tune in Tuesdays from 6 to 7 p.m. for Get in the Game with Dave Rothenberg right here on your talk alternative, WALE 990. From sports history to up-to-the-minute info, Dave watches the games so you don't have to.
Do yourself a favor and tune into your Talk Alternative every Wednesday at 9 p.m. Open the door to On Point with attorney Bill Cafaro and learn legal scenarios that will help you become better educated as a citizen, a potential juror, or a litigant. Covering issues ranging from capital punishment to wrongful death, this program will tackle pressing legal issues that affect not only society itself, but which may impact upon you personally. So join us every Wednesday from 9 to 10 p.m. for On Point with attorney Bill Cafaro on your All Talk All the Time station, 990 WALE.
You're listening to Southern New England's Talk Alternative, offering the most unique programming. 990 WALE, Renaissance Radio.